Hello, and welcome to California Gun Law. I'm your host, Don Hammond. Today I'm going to talk about the legal reasons that a sheriff or police department can deny your CCW license application in California. I'm a licensed California attorney and a shooting instructor. I regularly help teach the 16-hour class that's required to get a concealed carry license in California. On this program, we provide education on California's complicated web of gun laws so that responsible gun owners can better understand how to lawfully exercise their rights. California has a complicated web of firearms laws and regulations, and there are a lot of traps for the unwary. We want to help you do it right so you won't need our criminal defense legal services. Today, I'm going to talk about the reasons that a sheriff or a police department can deny your CCW license in California. First, we need a bit of background. The United States Supreme Court issued a decision called Bruin back in 2022, which affirmed the right to carry a firearm for self-defense as protected by the Second Amendment. That goes for both inside and outside the home. So that case struck down the good cause requirement that New York had. It also applied to other states, so California's good cause requirement went out the window at that point also. After that, California still had a dubious good moral character requirement. As a response to Bruin, the California legislature passed Senate Bill 2, which completely overhauled California's CCW application process. That took effect on January 1st, 2024. SB 2 eliminated the moral character requirement and made California a shall issue state. So why can they deny your CCW application? Well, according to Penal Code Sections 26150 and 26155, if you don't live in the jurisdiction where you apply, that's one valid reason. If you don't legally own the firearm that you propose to carry, that's another valid reason. And if you refuse to take the required 16-hour training program, that would be a reason for denial. Then there are all of the reasons listed in Penal Code Section 26202. This includes if you're reasonably likely to be a danger to yourself, others, or the community at large based on anything in the background investigation or the psychological evaluation that they can legally require. That's the most subjective reason for denial. Other reasons include if you've been convicted of contempt of court under Section 166, then you can be denied. If you've been subject to a restraining order that expired or was terminated within 5 years of your application, you can be denied. For now, that includes temporary restraining orders without even a chance for a hearing. But there's a bill in the legislature right now to try to change that. Within 10 years of applying, if you've been convicted of a hate crime or of any misdemeanor that makes you a prohibited person for 10 years, those are all listed in 29805, you can be denied. That makes sense, right? If you can't have a gun, then you can't have a CCW license. If you've engaged in the unlawful or reckless use, display, or brandishing of a firearm, that's also a reason for denial. The law doesn't list any kind of a time limit on that one, so I think it's an interesting possible case for appeal someday. If within 10 years of your application, you've been charged with a sex crime or a serious or violent felony, even if it was dismissed pursuant to a plea agreement or with a Harvey waiver, they can deny your CCW application. A Harvey waiver means that you are agreeing to pay restitution for a dismissed charge, usually as part of a plea agreement. In the 5 years prior to your application, if you've been incarcerated for or on supervision for a conviction of any drug or alcohol offense, then you can be denied. So this includes DUIs and drug possession offenses. Of course, if you're currently abusing drugs or alcohol, that can also be a reason for denial. If you have experienced the loss or theft of multiple firearms due to improper or illegal storage in the 10 years before your application, that can lead to a denial. And a failure to report a loss of a firearm as required by law can lead to a denial. So why can't they deny you? Well, they can't deny you for pretty much anything else. We commonly see denials for an alleged failure to disclose information on the application. That's not a valid reason for denial. Now, there is a criminal offense under Section 26180 for a knowing failure to disclose, but they would have to prove that you knowingly withheld that information in order to convict you of that crime. And of course, if you're convicted of a felony, that would be a reason for denial. There's also a provision to revoke a license if the agency later discovers something that didn't come up in the application process. But there's nothing in the law that says they can deny you for that failure to disclose. Of course, we recommend complete honesty on the application. Answer the questions honestly so that we don't have this problem, and your applications should go through pretty smoothly. Other things that are notably absent from the legal denial criteria are old misdemeanor convictions. If they don't make you prohibited, you should be good to go. 5150 mental health evaluations are not in the legal reasons for denial. Of course, a 5150 does make you a prohibited person for 5 years, unless you go back to court and have your rights restored under Welfare and Institutions Section 8103F. So during that 5-year period, or while you're a prohibited person, you would be excluded, but there's nothing in the law that makes you excluded otherwise if you have a 5150 in your past. Traffic tickets are not in the list of things that can make you excluded, even though they're asked about on the application, or whatever else they come up with to try to deny you. If they come up with something else, they'd have to make a link to a reasonable likelihood of present danger to society. And the California Supreme Court has highlighted that old conduct is no longer probative of present dangerousness after a period of good conduct and rehabilitation. That's from a case called In re Lawrence that I worked on while I was in law school. If your California CCW license application is denied, you can request a court hearing per Penal Code Section 26206. There, a judge will decide whether you should be disqualified from having a CCW license. We've won a bunch of these hearings, and we've lost a few. But don't lose hope, and don't be afraid to request a hearing. We've won in cases for supposed failure to disclose information on the application. We've won in cases with old 5150 evaluations. We've won in cases with negligent discharges. And we've won in cases where the applicant supposedly failed a psych evaluation in the CCW application process. In some cases, we even refer people to get a new psych evaluation in preparation for court to rebut whatever the psych said in the CCW process, and we've had some success with that approach. We recently posted other videos about how to apply for your CCW license in California and about the process of challenging a denial in court under Section 26206. So check out those videos for more information about those topics. I'm Don Hammond at California Gun Law, and we'll catch you all next time. Stay informed, stay legal, stay safe.